First, thank you for tuning in. I'm Eli Sluter with Sluter Law Firm. I'm a virtual in-house counsel. I help business owners from entrepreneurs with startups all the way through to established business owners who are ready to start thinking about succession planning. I help them with a wide range of legal matters, many of which will be topics of videos such as this one. Here's what we're talking about today. But before we get into that, I do want to remind you that while I'm licensed in Arizona, New Jersey, and Pennsylvania, this information is not state specific. It's just general information, not legal advice, and you watching this video does not make you my client. Okay? Let's talk business law. In this video, we're going to talk about choosing a business entity. Okay? Typical client, right? They're saying, I want to start a new company. What do I want to do? Should I use an LLC? Maybe a corporation? Maybe a partnership? How is each entity managed? Okay, these are questions that I hear quite often. Okay, first let's talk about how these entities are managed, and we're primarily going to be talking about the LLC versus corporation. I will touch on partnerships at the end and talk about why hardly anybody ever uses them anymore. With an LLC, you have maximum flexibility when it comes to management. With corporations, you have minimal flexibility. With the LLCs, the statutes that govern the LLCs typically say, unless the operating agreement says otherwise, whereas with the corporation, the laws really have a lot of formalities that have to be observed. So as far as management, the easiest, the most flexibility is member managed, right? Because the members manage the company. It's just one level of management. That's all there is to it. You also have manager managed LLCs. This is where you have your members appoint managers, and the managers run the company. Contrast that to a corporation. We have three levels, right? You have shareholders have to get together every year and have a meeting, and then they vote and they elect a board, board of directors typically. That board of directors then appoints the officers. These are your, by law, you have to have at least these three: the president, the secretary, and the treasurer. So those are basically the differences in the type of management structure that you can have with the two entities. So that's your basic management structures. Now let's talk about those formalities in a little more detail, right? With an LLC versus the corporation again, with the LLC, you have minimal formalities that are required. Really whatever the operating agreement says is what's going to be required as far as annual meetings, regular meetings, things like that. You do need to keep accurate records for the members, contact information, things like that. With the bookkeeping, making sure you're keeping track of money that has been put in by the owners and taken out, plus just sound accounting practices for the management of the business itself. You want to make sure that you're observing these minimal formalities, however, to make sure that LLC, you're treating it as a separate existence, like a separate person, if you will. You don't want to commingle your funds. You don't want to be paying personal debts with the business unless you're really accounting for it as a draw, and you don't want to be paying business debts with your personal funds, right? Yes, you can tag that as a capital contribution, but ideally you're not commingling those funds. You're keeping your business debts and liabilities paid with business funds and your personal debts and liabilities paid with your personal funds. If you do all that, you have the same limited liability protection as you do with a corporation, just with a lot less work. Okay, what kind of work is required with a corporation? There's a lot of formalities. By law, you're supposed to have annual meetings and these corporate minutes, consent to resolutions for big decisions. You have to keep your corporate binder together with all these documents and your bylaws, shareholder agreement, things like that. Even if you're just a single member corporation, you're just one person, you can be the president and the treasurer and the secretary and all those roles, but you're supposed to still document that each year you're getting together with yourself and appointing yourself as the director, and then each year you're appointing yourself as those officers. So it's just a lot of extra paperwork, and if you don't do it, it can be used against you, right? If you get sued, the company gets sued, I should say, the creditor that's suing you can try and pierce the corporate veil if you haven't been observing these things. And obviously the commingling and things like that is important as well. So those are the different types of formalities. A lot more work with a corporation, a lot less with an LLC. Okay, so we've touched on management structure and formalities. Real quick, I want to answer the question, why would somebody be a corporation over an LLC when there's so much more work? especially considering an LLC can elect to be taxed as a corporation, an S-corp or a C-corp? The answer really is if you are planning to take your company public at some point, or you're trying to attract venture capitalist funds. Those venture capitalists, they like to see the corporate structure because of those extra formalities. They want that's important to them. So that's why you might want to be an actual corporation versus setting up an LLC that's just taxed as an S-corp or a C-corp, and having that much easier time, much less formalities to observe, and much more flexibility when it comes to management. So now let's talk about protection from charging orders from creditors, right? What's the difference between an LLC and a corporation? First, you have to understand the difference between an outside and an inside liability. An inside liability is the entity itself is the defendant. It has breached a contract, or so it's done something that has gotten itself sued, and the creditor, the plaintiff, is going after the assets of the company itself. An outside debt, an outside liability, is when an owner does something. Let's say they run over somebody, or they get in an accident. Something happens that the owner themselves are being sued. They're the defendant, and the plaintiff is going after them, has got a judgment against them, and is now going after their assets. And one of those assets is their ownership interest in the company. So when it comes to an LLC, for an outside liability, this judgment, the creditor is going to go get a judgment, and then they're called a judgment creditor. And then once they do that, they can go get a charging order. If they can't garnish wages or bank accounts, something like that, they may go get a charging order against that owner's interest in the company. Okay, depending on the state that the LLC is in, that's doing business in, it might be that charging order is exclusive remedy. Arizona, Wyoming, Delaware, there's a handful of states where that's it. It's the exclusive remedy. That's all they can do is sit there with the charging order and hope that they get some profits, because any money that would go to the owner would then go to that judgment creditor there with a charging order. It's like an assignment of profits. Other states allow that judgment creditor to then foreclose that charging order. If it's not throwing out enough money to pay the creditor can foreclose on it, take over the interest, and take over management of the company, and can even force liquidation if they're a majority owner. With a corporation, by contrast, if this outside liability creditor gets a judgment, they can just go exercise on the stock and take it over. And then if they have a majority, again, they can force a liquidation of the assets. So that's a big difference between an LLC and a corporation, is when it comes to that outside creditor and that charging order protection. Okay, now let's talk about the differences between a C-corp and an S-corp. Before I get into that, though, I do want to remind you that an LLC can be taxed however it wants. It can elect to be taxed as an S-corp, for instance, but that doesn't change what type of business entity it is. It is only how you are treated for tax purposes by the IRS and probably your state as well. So real quick, what's the difference between a C-corp and an S-corp? With a corporation, with the C-corp, profits are taxed at the corporate level. Whatever the corporate tax rate is, whatever the profits are for that year, that's what the C-corp is going to owe. And then when it pays dividends, if it pays dividends to the shareholders will also be paying taxes on those dividends as unearned income, but still owing taxes. This is why a C-corp structure is known as the double taxation. But with a C-corp, we talked about if you wanted outside investment money, venture capital funds, they like this structure because they can get preferred stock, and then they get paid profits before the common stock does. With an S-corp, it's more like a partnership in that everything flows through. It's called a pass-through entity because the profits and the losses pass through to the shareholders, who then pay the taxes on them. But there are restrictions on S-corps as to what type of shareholder has to be. And if you violate these restrictions, if you, for instance, let a partnership be an S-corp shareholder, you are going to lose your S election, and then you're going to revert to being taxed as a C-corp. You can't have more than 100 shareholders. This is a closely held business structure. And finally, you can only have one class of stock, right? No preferred, no common. Everybody gets treated equally. Finally, let's talk about partnerships and why nobody really uses them anymore. First of all, by default, all partners in a general partnership are personally liable. There's no limited liability protection whatsoever. There are limited partnerships, but that require at least one general partner that is personally liable. And if this is used for any reason, that general partner is typically an LLC or a corporation, some sort of limited liability entity that serve as that general partner. There are also limited liability partnerships that have no general partner, but if you don't maintain those properly, then you can lose that limited liability protection a lot easier than you would with an LLC, let's say. And there's limited liability, limited partnerships. There's a lot of different LLPs, and it can get very confusing as to what's what. And frankly, ever since the LLC was introduced back in the late 70s, the use of partnerships have dropped off significantly because it's just so much easier to use an LLC than it is a partnership. So there you go. Thanks again for tuning in. I hope you enjoyed that short video, or if you didn't enjoy it, you at least found it informative. My name is Eli Sluter. I'm a Sluter Law Firm. I'm a virtual in-house counsel mostly to business owners and real estate investors. I help with a wide range of business and contract matters, anything from non-disclosure agreements, independent contractor agreements, buying and selling businesses, things like that. Estate planning, I can help anybody with estate planning, but it's especially important for business owners to have an estate plan in place early. Succession planning, that includes buy-sell provisions or standalone buy-sell agreements. Asset protection is something that applies to everything that I do. Real estate, anything real estate and related, whether it's residential, commercial, whether you're buying, selling, or leasing, and if you're leasing, whether you're a landlord or a tenant, I can help. Finally, trademarks. I want to make sure that the brand that you are putting all your blood, sweat, and tears into building is something that you can protect and that isn't infringing on somebody else's rights. Like with everything else that I preach, it is very important to remember that an ounce of prevention really is worth a ton of cure. Why do I preach that so much? Because I've seen the ton of cure too many times. So please give me a call sooner rather than later. I'm happy to help you. All right, thanks again.